Welcome everybody. Goeiemorgen, goeiedag, hello, wherever you are in the world. We've got a wide range of participants from all over the world today. It's 8 a.m. here in New York City. My name is Dr. Leon Perlman. I'm head of the Digital Financial Services Observatory at Columbia Business School. And I'm happy to welcome you to this webinar on AML Trends in the Developing World and the impact of 30 years of the first course. We're privileged today to have Professor Louis de Koker from Australia, at Trobe University. He happens to be in the US at the moment. One of the world's foremost experts on the topic, and he's at the FATF plenary currently. So, if I may, just an introduction to the webinar. If you could please keep your microphone off and your video off, please. Please do not ask questions by audio at any time. You are welcome at any time to send questions to the host via the platform. And you don't need to wait to the end. Find an interesting issue to ask a question about, please send it in the chat box to the host, Jason. Okay, a bit about the observatory. We're based here at Columbia University at the Columbia Business School. We are financed by the Bill and Melinda Gates Foundation. And you're very welcome to go to our website, dfsobservatory.com. And it's quite an extensive website with a large legal database. That's the DFSO team, and you see that picture on the left. We're in the little green patch sort of in the middle, right there. Professor Ali Noam is the director of CITI, under which the observatory fits. That's me on the top right. There's Michael Weschler, who's the technical host today, research scholar, and Jason Buchweitz, who's the executive director. That's me. I'm head of the observatory, head of a couple of work groups under the Nations Union on DFS, blockchain, and security, and legal aspects. So today's presenter is very fortunate to have Professor de Koker, a good friend of mine and a good friend of the DFS Observatory. He's Professor of Law at Trobe in Melbourne and CGAP's financial crime consultant. His research in the past few years has focused on managing the relationship between financial inclusion and AML and CTF finance, especially in relation to customer data. So I will now hand over to Professor Louis de Koker in Orlando.
Thank you so much, Leon, and good day to everyone across the globe. Thank you for joining us for this webinar that focuses on AML trends in the developing world and also links with reflections on 30 years of FATF. Both are huge topics. So Leon and I thought we should perhaps focus attention on three broad strands for this discussion. Firstly, a few perspectives on FATF, the Financial Task Force, and the developing world, and 30 years of progress. And against that backdrop, on custom due diligence and changes, so that we could link to trends and then perhaps end also with questions on looking back and reflecting on that, where it may be taking us in the future. I think many people in this call knows that FATF is the global intergovernmental standard-setting body for three important topics. Often the focus falls only on the first one, the oldest one, anti-money laundering, but also key, generally included in the abbreviation AML CFT, or in certain parts of the world CTF, is combating and financing of terrorism. And then a key other strand that sight is often lost of is proliferation financing in relation to weapons of mass destruction. The focus certainly falls on the first two, but the importance of the third one is emerging, and that will also hold implications for developing countries, but not necessarily from the perspective that we look at FATF this morning, and this is mostly from a financial inclusion perspective on developing countries. Now, this year is special because 30 years ago, FATF was established by the G7 plus 1 meeting, which was then the European community that joined the 7 biggest economies in the world at a meeting in Paris. And it was set up as a temporary task force with a brief to come up with good ideas about how to protect economies against proceeds of crime. And they completed their work in a few months. Early in 1990, the work was completed and they could present it to the next G7 meeting, then in the US, and it became adopted and then known as the 1990 FATF recommendations. So next year we will celebrate 30 years of international standards. But this week, speaking to you from Orlando, with a conference center just outside my window, where the meeting will start shortly, and I'll join it a bit later after the webinar, FATF is celebrating its own 30th birthday. It's a little bit early. July is more accurate, middle of July. But given that FATF just meets 3 times a year in plenary, this is the closest meeting and a very good excuse for a very good celebration in the US this week. From a developing country perspective, at the start, there was perhaps less reason for celebration. And certainly for basically the first 2 decades of the international standards, there were tensions between developing economies and the developed economies, and in many fora, the FATF recommendations were dismissed as developed country focused, enforced on developing economies. Much has changed, and a lot of that has changed in the past decade. And it's extraordinary. And these standards are now endorsed by 200 jurisdictions in the world. Membership of FATF has also changed, especially since the late 1990s, slowly and then faster over the past few years, with countries like China, Brazil, Indonesia, Malaysia, Mexico, South Africa. I could add to the list India, Turkey, and so forth, joining the membership. And the membership is exclusive, 36 countries and 2 regional organizations at the moment. And developing countries may look at that and say, but we are still in the minority. But FATF operates on a principle of consensus. And it's gratifying to see to what extent developing country delegations participate in important policy decisions and often send the policy decisions in a different direction than it might have taken, but for the input. And then, of course, around the table, there are observers like the World Bank, and also as associate members, 9 FATF-style regional bodies globally that basically represents all of the other 200 jurisdictions that are not that do not directly have a seat at the table. So as a result, in the past decade, we've seen a far greater sensitivity to issues relating to development and capacity, and importantly, in relation to inclusion in the past decade. And that's very important, especially from the perspective of this webinar, focused on digital financial services, as digital financial services is such an important vehicle for supporting increased financial inclusion globally. Now, to change the focus to customer due diligence standards, I think it's important perhaps to take a step back 30 years or 40 years. And if I look at the people who've joined, it's quite probable that many of you weren't around opening bank accounts 40 years ago. It was very different. I can still recall opening a bank account when I was young without having to present any documentation. I wasn't even required to have the assistance of my parents. And I closed the account in disgust when 2 years later, a bank official told me I'm actually not supposed to have the account because I'm a minor. Banking was done on trust, and customers were accepted on trust. This started to change, and initially quite slowly with the acceptance of the 1990 recommendations. The key, what is now known as the CIV element of customer due diligence, the customer identification and verification element, was captured as follows, and I printed the relevant part on the slide. That financial institutions should be required either by law or, interestingly enough, by self-regulatory agreements among financial institutions. So a very soft start to it, to identify on the basis of an official or reliable identifying document their customers, either occasional or usual. So it didn't even require a country to adopt a law. Self-regulatory standards were fine, but the focus was very much on official or other reliable identifying documents. That started to change slightly in 2003 with the adoption of the next big set of revised recommendations. There was an interim revision in 1996, but it didn't touch on these issues. It required the identification of the customer and verification that of the customer's identity, so language that's familiar now, using reliable independent source documents, data, or information. Now, that provided a very important link for the issues that we are grappling with at the moment, because it moved the need to use reliable documents to the possibility of using reliable independent data or information. But still, despite that major achievement in 2003, we still grappled with the legacy of 1990. For instance, the phrase identifying the customer and verifying the customer's identity was very much viewed as a single concept. And it was used by FATF and its assessors as a single concept, identification and verification, as one step. It took work in 2011 done by the World Bank to clarify that these are actually two different processes. Identification is one process of getting identifying particulars, and verification is a process of verifying some of those particulars. So in 2003, we received language that was helpful, but it took time for the mindset to develop. Importantly, 2003 also allowed the performance of CDD on a risk-sensitive basis. But it took till 2007 for FATF to really come to grips with what that meant when they started issuing high-level guidance after long debates and sometimes very intense debates at FATF, because most of the FATF members were still very much invested in a strict rule-based approach. And that, of course, brings us to what we now know under Recommendation 12, relating to CDD measures with four broad categories. Customer identification as a process combined with a second process around verification of customer identity, establishing beneficial ownership, assessing the risk posed by that customer and risk profiling the customer, leading us into ongoing due diligence, monitoring the customer's transaction, using the profile to identify unusual transactions or those falling outside of the parameters, and then reporting those to the financial intelligence unit. Important in 2012 was the introduction of the risk-based approach as mandatory. So in 2003, it was optional. In 2012, it became mandatory and linked to the possibility of recognizing lower risk in relation to appropriately defined financial inclusion products with an assessed lower risk profile. So where are we today? Well, something that's not often appreciated by many people who followed FATF closely in the previous years was that after 2012, the revision of the FATF standards that was so clearly linked to 1990, 1996, 2003, and 2012 fell away, and the process became continuous, which means that plenary after plenary and year after year, there may be changes, often microscopic, but important to the recommendations or the interpretive notes or the glossary that together make up the international standards. Importantly enough, for this discussion too, this week we'll see the adoption of virtual asset service provider recommendations. The main set was adopted last year, recommendation 15, but the important final text of the interpretive note and of the guidance note that accompanies it will be linked to this plenary, and we're awaiting the final public statement that will be issued directly after the plenary. This deals with providers of what is known as cryptocurrency services. And importantly for developing countries, do keep an eye out for the approach, whether you view it as sufficiently balanced to allow also for the recognition of lower risk providers of services that are especially geared at supporting financial inclusion. FATF has also announced that it is under continuing work at the moment on digital identity, which is going to be important for digital financial services, probably to be published next year. Another important milestone earlier this year was the fact that FATF was given an open-ended mandate. So until now, FATF has been operating under a very limited, time-limited mandate. Initially, they were set up as a task team to operate for a year. Then they were given an extension of another year. And since then, that pattern has continued over 30 years until in March this year, their ministerial ministers gave them an open-ended, undated mandate. And importantly, that mandate was accompanied by a ministerial declaration affirming that FATF will continue to promote financial inclusion. Now, to turn the attention to Cdd Trends. Since 2012, to advance inclusion, I'd say there were two broad approaches that were particularly significant. Firstly, using simplified CDD, often incorporating elements of a tiered-based approach. So the mandatory risk-based approach allowed for the identification of lower risk customers, products, and services, and then for the appropriate simplification of CDD measures in relation to those lower risk categories. Parallel to that trend has been the improvements in biometric national identity systems, together with the linkage of that to CDD processes, in particular CIV, the customer identification and verification processes. These are generally referred to as eKYC. We prefer to use CIV. KYC is not FATF language and is a bit blurry because some people use KYC to refer to the broad CDD process, all four categories, while others use it to refer only to CIV. So to prevent confusion, I'm trying to use CIV generally, except where a country or a market has really appropriated the term eKYC as their terminology. Added to this, we, and if I use we, I'm speaking from a CGAP perspective, see a third trend reflecting on these first two, but also broader, of collaborative CDD that I will make some remarks about after touching on tiered CDD and developments in national biometric identification. So tiered CDD, just to clarify that for purposes of discussion, refers to those cases where a system emerged that allows for higher levels of product functionality accompanied by increasing levels of CDD, so that there is a graduation that allows for very simple products with limited functionality to be offered to customers on the basis of limited or simplified CDD, but keeping the door open that those customers or any other customers that are able or want to submit to increased CDD are able to access products with a higher functionality. Now, this was a system adopted by South Africa in 2002. It was a system that was closely, and an approach that was closely studied, especially by Mexico. It was increased by Mexico to 3 in 2011. It's been used also by Pakistan and Nigeria, that also looked at what South Africa was doing and what Mexico was doing. And a number of countries now have tiered CDD approaches, often spelt out, but not necessarily in regulations. The regulations are sometimes binding, generally not, because the regulators need to be careful. The mandatory risk-based approach requires them to allow institutions to do their own risk assessments. So if the tiered CDD approach is set out in regulations, it should still allow the institutions to undertake their own risk assessments and fit their customers and products within the tiered-based framework provided by the regulations. Mexico, when it adopted the system, took an important step. It was the first country, and still the only country that I'm aware of that did that, that allowed the issuing of basic products without customer identification or verification, with very limited functionality. And they did that using a possibility under FATF of not simplifying CDD, but actually exempting specific products or providers or activities from AML CFT requirements on the basis of a risk assessment that proved that they posed not only a lower risk of money laundering and terror financing, but a low risk. And important enough, Mexico's approach was actually endorsed by its FATF peer review assessment when it was subjected to mutual evaluation. Mexico is, however, to my understanding, revisiting that approach for commercial and other reasons, and apparently we may see changes in that regard. India and the Philippines have also are examples of countries that have followed a similar but also slightly different approach by allowing small accounts with very restricted functionality to be opened by customers without undergoing ID verification, but providing a time limit, providing them some time to use that account before they have to submit to identity verification, and if they fail to do that, they lose access and functionality of that account. Now, eKYC has been another important trend. Important steps has been taken in this regard by Pakistan under the NADRA model, expanded by India, and a lot of attention has been given by a range of developing countries to the models that have emerged from that part of the globe. Now, for purposes of this, even though I'm going to focus on the Indian model, we can also discuss the model in Pakistan. In India, essentially, since the Aadhaar biometric national identification process was rolled out in 2009, more than 1.1 billion people have been enrolled. It's been spectacularly successful in coverage, and their enrollment has been accompanied by the provision of biometric data, especially fingerprints. And that enabled India to allow an eKYC system that enabled clients to open up accounts by approaching a bank agent, by using a fingerprint scanning device, like the one that you see on the screen at the moment to the right, where the customer would scan the fingerprint. That fingerprint would be matched against the formal national identity data of held on that person, and if there is a match, and with the customer's consent, that data, the biographical details, may be released to the provider, which basically means that the bank account opening form is populated directly by the National Identification Authority. And the provider of the services, for instance, the bank, does not need to take any further steps to verify that data. Now, this has led to significant compliance relief for the provider. It means for the provider and also for the country a high level of identity verification, plus full cost saving in relation to verification processes that can often be costly. So eKYC has been particularly successful in India commercially and to increase inclusion. But it was accompanied by increasing concerns in the community around data security and data protection. And that led to legal challenges brought by retired Judge Puttaswamy, that you also see on the slide, who has proved very tenacious in presenting these big questions to the highest court in India, the Supreme Court. And in 2017, based on a challenge he brought, in an exhaustive and thoroughly scholarly judgment delivered by the Supreme Court, it recognized a constitutional right of privacy in India, essentially requiring the Indian government to ensure that a new data privacy law is drafted and adopted to give effect to this recognized constitutional right of privacy. Now, with that as the foundation, a second case was brought challenging ADA, the ADA identification system, and the ADA Act that was adopted after the system was introduced to provide a legislative basis for the system to challenge that act on constitutional grounds. The Constitutional Court or the Supreme Court upheld this act on constitutional grounds, but struck down a very important section that actually allowed commercial usage of eKYC. Now, this had severe implications. Firstly, big legal uncertainty. Around continued access to the UIDI basis, and it became quite clear very soon that access had to be stopped. It created big questions regarding customers that were already in the system, identified using their data, and commercial providers and banks had to resort to a variety of mechanisms, including documentary-based identification and other means to try to give effect to the judgment within what was then clear about the law. Luckily, earlier this year, the government intervened by publishing a temporary ordinance restoring temporarily financial institution access to eKYC under specific rules, pending the preparation and adoption of legislation that would provide a firmer basis for the access that commercial institutions can enjoy to eKYC services. Now, it is quite probable that that legislation too will be subjected to a constitutional challenge. It will provide an important foundation like the ordinance did, at least for practices, but until there is final clarity coming from a Supreme Court judgment, it is quite possible that uncertainty may continue. Now, further in relation to India's eKYC system, in the midst of the legal uncertainty, India also introduced fees for the first time regarding eKYC access and usage. Providers had now to contend not only with legal uncertainty, but also the commercial uncertainty that was caused by this new intervention. And I'll return to this, but I'd like to position this as an important part of the lessons to be considered, because looking at these examples and what Indian providers have been exposed to in the past months, it is, I think, important to recognize that while digital identity, especially that provided by government, provides us with far easier ways to perform these CDD functions, it is important to have appropriate privacy and data protection frameworks in place to prevent concerns that may lead to disruptions down the line, whether legal or political. And then it's also important to consider commercial risks, and there we can touch on Pakistan too, because it's not only the legal risks, it is the commercial risk. Because once everyone becomes used to using the service, it's quite possible to ensure an appropriate service and quality service that government will decide to introduce fees. And once introduced, as we've learned with taxes, it is quite possible that they will rise and may continue to rise. And then, of course, we have the developments such as those that we've seen this week, with further disruption in the market and other models that may emerge around Facebook and its Libra announcement. But we could perhaps leave that particular topic for question time. This brings me to what I'd like to position in broad reflection on some of the materials and ideas that I presented around the trends emerging. And that is what we've identified as part of a CGAP project as a pattern of collaborative CDD or CCDD, if you love using acronyms that are forming, essentially where technology is being leveraged to share the CDD burden that previously had to be carried by each regulated institution on their own. And there are public models, there are private models, there are public-private models. I'm not going to go into a huge amount of detail. More of our thinking will soon be available when the researchers, Tim Lyman, Chrissy Martin-Meyer, and Mehmet Köse's working group or working paper, Beyond KYC Utilities, Collaborative CDD for Financial Inclusion, will be published. But you can see some blogs already on the thinking in the link on that slide. So what are examples? Well, certainly the Indian example of eKYC and of Pakistan is a great example of collaboration. Previously, institutions had to perform identity verification on their own. Now, we've seen models, and they are emerging in further countries too, of governments coming to assist and working with institutions to provide them with access to data that they've not had before in order to perform CDD more effectively and more cheaply. We also see industry models emerging, and that's where KYC utilities fit in. So KYC utilities are essentially models where more than one financial institution are pooling their customer data, often under an independent institution, a vehicle controlled by them, for instance, in an industry, so that there's a central customer data pool, which enables institutions that first deal with a customer to pool the data in that pool, and then second or third institutions that the customer may deal with have access to that pool of data, can pull it into their forms, and when the data is updated, some of them also update the information, and it's available to all of the members of that KYC utility. Now, these are also called sometimes KYC registries. A good example is the SWIFT KYC registry that it developed for correspondent financial institutions of SWIFT. And they collect corporate information on their participants. SWIFT recognized that through their relationships, there are more than 1.3 billion correspondent banking relationships, and every banking correspondent has to ensure that it holds information and verifies information about every other correspondent in its network. And by pulling that data centrally, they can help everyone to have a more efficient and cheaper service. A similar idea, but in relation to corporations, was investigated in Singapore by the Association of Banks in Singapore, the ABS, to pool data on corporate customers of financial institutions in Singapore. That project was particularly interesting because they suspended the project last year in September, because the model that they pursued actually proved too costly. The combination of the setup costs of the utility, the expenses of migrating historical bank data to the utility, and then the investment required by each bank to procure and implement the required technology, as well as the organizational changes made that less feasible. So they suspended it. We also see private sector ID initiatives, such as those provided by companies like Yoti, that provides a free app-based ID wallet, or Gravity, that allows people that may not have official identity to build an identity wallet and an identity score. For instance, using the person's social network to confirm that the data is actually true and correct. They are also part of new collaborative models that are emerging in the CIV space. We also see corporate models such as Refinitive's KYC as a service. Now, Refinitiv provides information, for instance, on PEPs, politically exposed persons, and sanctions lists in WorldCheck. But all of the members and users of WorldCheck can use the WorldCheck service to input information about new risks and people that have been identified, and if investigated and found to qualify for inclusion on the list, may be included by Refinitiv for use by all of its users. And then we also have financial intelligence sharing partnerships that are emerging, where FIUs and banks and other regulated AML CFT entities are starting to share data, working together, often in a task team format, to co-investigate specific trends, which is hugely helpful because it provides the institutions with far better insight into emerging money laundering and terror financing risks than they've had before, and that in turn assists in improving their customer risk profile and their own customer risk assessments. Now, to close perhaps this discussion on a few questions around the future. Collaborative CDD is certainly a key trend. All of these initiatives around technology are exceptionally powerful. Looking at what we now have, not all of the CDD categories are yet covered by any particular CDD initiative. So most focus on the first element, CIV, some focus on beneficial ownership, some focus on risk profiling, and ongoing due diligence. But what we think will emerge is that more of them will start developing services that cover more of these categories. Have a look at the soon-to-be published working paper that will be available from that link, that will provide a typology that may be helpful to map these developments. Certainly, technology is going to be very important, and we haven't touched on how technologies are important, but just for the moment, weave in artificial intelligence and how enhanced data analytics can change CDD and, frankly, AML CFT practices in general. But because all of this is so heavily data-based, it may require, again, looping back to the continuing history of development of FATF and its standards, it may require changes in standards, especially around things, for instance, like tipping off. The tipping off provisions of FATF and in laws are now starting to become a barrier to information sharing between institutions that need to share the information to actually combat money laundering, not to tip off the money launderers, but to work together and share data to combat crime more effectively. And to end on that note, so ladies and gentlemen, the FATF story and CDD will continue into the next decade. Leon and Mike, with that, over to you.
Thank you, Professor de Koker. Baie dankie, as I say in Afrikaans. That was super comprehensive and super interesting and very timely given your participation in the FATF plenary in Orlando. Just for those who joined late, I'm Dr. Leon Perlman, head of the DFSO at CITI at the Columbia Business School in New York. And as I invited you all at the beginning, was to send questions through. And if you still have, there's still time to send questions for Professor de Koker. And quite a number have come through, so let me get right to it in the interests of time. Safik in Lahore, Pakistan, asks about the risk-based approach, which he says has meant in many countries there's been no proper guidance from regulators and has resulted in providers having to make up their own rules to satisfy the regulators, and has created enhanced due diligence and has resulted in excluding people, which is against financial inclusion. His question is, should FATF issue a guidance to fix this?
Leon, Safik, a very good question, and yes, it's problematic. Let's just appreciate the difficult position that regulators find themselves in. Under the risk-based approach, they may actually act in contravention of the FATF standards if they provide too much guidance that starts veering towards the old rule-based approach that was replaced by the mandatory risk-based approach in 2012. But certainly, FATF has recognized this concern. So in 2011, FATF for the first time issued financial inclusion guidance. In 2013, after the publication of the 2012 standards, it revisited that guidance and revised it to reflect the new standards. It was really issuing that guidance to help countries and regulators and providers to think about financial inclusion and lower risks, and they wanted to unpack these standards. And still, that was not sufficient to really see sufficient adoption of simplified due diligence. So FATF again went back to the drawing board and launched a further project collecting examples of simplified due diligence. And this was published in 2017 by republishing the 2013 guidance note with a new annex with those examples. So there are examples available. And FATF has really gone out of his way to publicize these examples. The ball is now in the court of regulators and providers and industries and financial inclusion experts to come to the party. I think there's a lot of information available. What needs to be done are proper risk assessments. To design appropriate controls is not as difficult as it is to design and undertake a credible risk assessment. And I think we perhaps need to focus a little bit more on assistance in that regard, also for providers. And then what I can do is point you to the FATF website and this guidance with this annex. And if that's not helpful, please reach out. I'm very happy to cast around for even more examples, Safik.
Okay, thank you, Professor de Koker. We have a question from, and not surprisingly, on blockchain and cryptocurrencies. Actually, a few questions, but I'll choose the two that came in first. From Gil Laxon, I'm not sure where Gil is, asking, while it's still early days with the proposed Libra cryptocurrency, which of course is the Facebook one, what are your thoughts on this, especially from a perspective from AML CFT? I know that's a pretty broad question.
I think, like many of you, I'm trying to understand their model. What I've seen at this stage is, well, let's start at the beginning. What they've proposed appears to be a model that will be covered by AML CFT regulations. Um, which regulations will apply, given that Libra is going to be based in Switzerland? It's probably going to be the Swiss regulations that apply, and that will require customer identification and verification. I have seen that the intention is to use uh, state-issued, government-issued identity documents and data, that the intention is not to use social media and profiling data. Uh, all of this is uncertain. Um, I think we're all in the same boat together with regulators and fascinating discussions this week for this announcement to coincide with a FATF plenary. It was quite interesting. As you can imagine, there's been a number of tea time discussions around the model, but there are just at this stage too many question marks hanging. And then, of course, we'll have to see whether this actually gets out of the starting blocks, whether that is going to be allowed by regulators. What will be relevant, depending on the model, is probably the new virtual asset service provider standards. And what they essentially do is just apply the existing FATF recommendations in relation to cryptocurrency service providers.
Okay, and as we know, there are a lot of U.S. states that have created their own blockchain laws with very interesting AML CFT requirements, which personally I think may be very, very difficult to implement, especially as they revolve around identifying people doing anonymous or pseudo-anonymous Bitcoin transactions. And essentially makes it illegal if you transact and you don't have the recipient or and this is just on a peer-to-peer basis, recipient or sender's identity. So very difficult. It's a proposal, legislation, but we'll see how that works out. I think this technology challenges everybody from service providers to regulators.
And Leon, perhaps in that regard, you are touching on an important issue. FATF focuses on regulated financial institutions because it works with regulators. So the peer-to-peer market is something that falls outside of the FATF ambit.
Agreed.
But certainly, I don't see a rosy future for anonymous transactions of value in any form whatsoever. How long that future is, that we will have to wait and see. But that is not where the world is leading.
Well, as you know, there are two types of models for exchange, or actually three types of models. One is kind of regulated exchanges that if you cashing in and out, if you will, between fiat currencies, so you're buying cryptocurrencies, and you're selling cryptocurrencies, that touches definitively on AML CFT. What's less clear, it seems, is whether or not an exchange, if it's a centralized one, is allowing you to just exchange cryptocurrency. So there's no fiat component. And then the third one is not so much an exchange, but a centralized exchange, but a decentralized exchange in the true sense. Not an exchange that is swapping, allowing you to swap decentralized currencies, but those are what's called atomic swaps, where effectively that's a peer-to-peer model. And those are three different challenges, I would think, to regulations. The last one probably being the most difficult because it's a true peer-to-peer model. And that technology is rolling out. We'll see where that goes. So a few other blockchain questions, but let me get to another one. What is this is from Gabriela Salvatore in Lima, Peru. Professor de Koker, what is FATF doing about de-risking?
It is de-risking is a major concern, not only for FATF. If certainly, FATF issued its first statement in 2014 around its concerns about de-risking, but it is an issue that cannot be solved by FATF on its own. So it has been working closely with other standard-setting bodies, also with the FSB, reporting to the G20 around de-risking, following the trends, but also looking at potential interventions. It's proved a very difficult problem to solve because it's so deeply embedded in the risk-based approach, but also because much of what's now called de-risking is also driven by other factors in other standards, such as Basel III. And there's a convergence. So hence the importance of working with the other standing setting bodies, the FSB, and also the G20 in the form of the GPFI, the Global Partnership for Financial Inclusion. It's a fascinating discussion. I wish answers were much easier and much clearer, but it is a problem that's continuing to receive serious attention at the highest levels. It does require everyone to improve practices, regulators, certainly supervisors. If many of the de-risk entities were better supervised, if we saw better fit and proper tests applied, if we saw better compliance practices, banks would be in a better position to make decisions that would lead to relationships being retained. But from a general inclusion perspective, we're all in the same boat, and we're very concerned about it in relation to money transfer services, also in relation to correspondent banking relationships.
Is that perhaps going to drive, or has it drive any evidence of it driving de-risked entities or persons into the shadows?
Oh, yes. Look, we've done research in my own hometown town in Melbourne, working with remittance communities, where some of the businesses are still registered with the AML CFT authority, but they've lost their bank account. They're purely operating in cash, and then they are couriering the cash out using cash couriers who declare the cash, often hundreds of thousands, if not millions, at the airport, and they fly to take the money with them.
Yeah, I've heard those stories. In fact, yeah, in the U.S., the Somali community, large one in Seattle, sends briefcases with hundreds of thousands of dollars on an Emirates flight every single night, and sends it to, effectively, the money lands up in Djibouti, where they buy tires. And those tires are then sent into Somalia and effectively sold there for cash, and that's how the remittance gets through. Is obviously there's a lot of haircuts, so the value that you send, the value the person gets is changes, but it
I understand. I'm not speaking on behalf of FATF, but I'm an observer. They get this. This is not the result anyone who's concerned about money laundering and terror financing wants. So there's a high level of serious engagement of this issue, but it's hugely complex.
Understood. And in that regard, the DFSO is developing 2 papers on de-risking as well, so look out for that. And also, of course, as Professor Koker mentioned, look out for the CGAP paper coming out very soon, and the link was on the slides, but go to the CGAP website. Professor Koker, when do you expect that to be released?
Well, it is being set at the moment, so we're in the hands of the publication producers. Hopefully, very early in July.
Okay, fantastic. Go onto the DFSO website, sign up from the mailing list, and we'll let you know when our papers are released. And correspondingly, go onto the CGAP website, cgap.org, and sign up and for the newsletter, and you'll be informed when that paper from Professor de Koker and his colleagues at CGAP is released. And with that, I want to thank Professor de Koker for a very informative discussion. As I said, very timely given your presence right at the epicenter of AML CFT at the FATF plenary in Orlando. And thank you for getting up early to participate in this webinar. And for everybody that sent in questions, thank you. They were most informative. And also thank you for your attention and participation. This webinar is being recorded and will be placed on the DFSO website, dfsobservatory.com, within the next week to 10 days. So if you arrive late, you can watch the full recording on our website. So again, thank you everybody from New York City. Thank you to Michael Weschler for doing an excellent job at the technical back end of this webinar. And with that, I wish you all a farewell. Goodbye and see you next time. Thank you, Professor.